The courtroom doors were still swinging shut behind him when my son looked over his shoulder and laughed. Not a quiet laugh, not even a nervous one. It was the kind of laugh a man makes when he's already certain he's won, loud enough for the gallery to hear, loose enough to embarrass someone. He leaned toward his wife, and she pressed her lips together to hold back her own smile. And then he turned back to look at me sitting alone at the defendant's table and said, loud enough that the court reporter glanced up from her keyboard, "Dad, you couldn't even afford a parking meter downtown. Who exactly is going to represent you today?" His wife, my daughter-in-law. Renee put her hand on his arm. Not to stop him, to steady herself because she was laughing too. I didn't answer him. I just looked at the door, and then it opened. "My name is Harold Gaines. I am 67 years old. I spent 31 years as a high school history teacher in Clarksville, Tennessee, and another 6 years after that, helping my late wife Margaret run the small bed and breakfast we turned our farmhouse into after we both retired. Margaret passed 4 years ago, pancreatic cancer. 8 weeks from diagnosis to the end, and I have spent every morning since then, waking up on her side of the bed, because mine still smells like the cedar chest she kept at the foot of it, and I cannot bring myself to move it. I tell you that so you understand what this house meant to me, what it still means. The farmhouse sits on 11 acres just outside of Clarksville. Margaret's parents built it in 1958. She grew up there. We got married under the oak tree in the back field. Our son, Mitchell, learned to ride a bicycle in the gravel driveway. When her parents passed, Margaret inherited the property, and when Margaret passed, she left it to me, along with everything else, which wasn't much, but was ours. Mitchell was 38 years old and living 40 minutes away in Nashville when his mother died. He came to the funeral. He helped carry the casket. He stood next to me at the graveside and put his arm around my shoulders and said, "Dad, whatever you need." I believed him. I should tell you that plainly. I believed my son. I want you, friends, to understand that I am not a suspicious man by nature. I am a man who spent 3 decades teaching 17-year-olds about the lessons of history, and who somehow, stubbornly, kept believing that people were mostly trying to do right by each other. Margaret used to say that was my best quality and my worst one, both at the same time. She was right. She was right about most things. The trouble started small, the way it usually does. About 8 months after Margaret passed, Mitchell began calling more often. Not to check on me, or not only that. He started asking questions about the property taxes, about whether I'd had the roof inspected lately, about what the bed and breakfast brought in each season, and whether running it alone was really sustainable for a man my age. "I'm not that old, Mitchell," I told him once. "Dad, you had a dizzy spell last March. I stood up too fast from the garden." "That's not the point. The point is you're out there alone on 11 acres and nobody's checking on you." He came by more, started bringing Renee, which I didn't mind. I had always tried to like Renee. She was sharp and capable and organized, and she had given me 2 grandchildren, which meant I would extend considerable goodwill in her direction regardless. But I started noticing things. The way she walked through the house with her eyes going to the ceilings, the floors, the window frames. The way she asked questions about the original construction. The way she mentioned, twice, in the same visit, that properties like this one were selling for remarkable prices in the current market. "I'm not selling," I said. She smiled. "Of course not. We're just saying you have options." It was my granddaughter Lily who first told me something was wrong. Lily was 17 at the time, Mitchell and Renee's oldest. She was quiet and serious and read constantly. And of all the people in my family, she was the one who reminded me most of Margaret. Not in looks, but in the way she paid attention. Margaret had always said the most important thing a person could do was pay close attention to the world around them. Lily did that. She watched everything. She called me on a Tuesday night in November, about 14 months after her grandmother's death, and the first thing she said was, "Grandpa, do you know what a power of attorney is?" I told her I did. She was quiet for a moment. Then she said, "Dad had a stack of papers on his desk. I wasn't snooping, I was looking for a charger, but I saw your name on them, and Mom's handwriting in the margins." I asked her what the papers said. She read me what she could. It was enough. What Mitchell had done, or had been trying to do, was file for conservatorship over me, not power of attorney, which I might have understood, or even agreed to in some limited form. Conservatorship. the legal mechanism by which a court declares a person incapable of managing their own affairs and assigns someone else to make decisions for them. Financial decisions, medical decisions, housing decisions. My son was trying to have me declared incompetent, and if he succeeded, the farmhouse, Margaret's farmhouse, the one she grew up in, the one where she died in the bedroom upstairs with the window open because she wanted to hear the birds would fall under his management. He could sell it. He would sell it. I knew that the moment Lily finished reading me those pages, I sat in the kitchen for a long time after we hung up. The house was very quiet. I could hear the oak tree moving in the wind outside. Then I got up and made some phone calls. What Mitchell didn't know, what neither he nor Renee had thought to look into, which told me something about how certain they were of winning, was that 6 months after Margaret passed, I had quietly consulted a lawyer named Patricia Odom about the estate. Not because I suspected anything, just because I am a man who has taught students about what happens when people fail to document things, and I wanted to make sure everything was properly in order. Patricia Odom was 61 years old, semi-retired, and had spent 22 years as a family law attorney before opening a small practice in Clarksville that she ran mostly out of professional habit, I suspected, out of genuine love for the work. She was small and precise and wore her silver hair in a bun so tight it looked architectural. When I called her the night after Lily's phone call, she listened to everything I said without interrupting once. When I finished, she was quiet for a moment. Then she said, "Harold, do you still have the medical records from your last 3 physicals?" I did. "Good. Don't do anything yet. Just get me those records and come see me on Thursday." The conservatorship petition hit me officially the 2nd week of December. Mitchell filed it in Montgomery County. The grounds he cited were concerning he had found a doctor, someone I'd never met, willing to submit an affidavit suggesting I exhibited signs of cognitive decline based on a wellness assessment I had apparently taken as part of a free community health fair the previous spring. I remembered that health fair. I had gone because the church organized it, and they were doing free blood pressure checks. I had not known anyone was evaluating my cognition. I had not consented to any such evaluation being used in a legal proceeding. Patricia read the affidavit twice. Then she set it down and looked at me over her glasses. "Mitchell's attorney is good," she said. "He's done this before. They're going to paint a picture of a grieving, isolated elderly man showing early signs of decline. They're going to suggest the house is at risk, that you're a fall hazard, that you need supervision. They'll make it sound like they're doing this for you. Can they win?" I asked her. She folded her hands on the desk. "Not if we do this right." What we did, over the next 2 months, was document everything. I underwent a full neuropsychological evaluation at Vanderbilt, 3 hours, with a specialist who tested memory, reasoning, processing speed, language, spatial awareness. I scored in the 91st percentile for my age group across all categories. Patricia got that report certified and filed it. She also obtained my last 3 years of medical records, which showed a man in good health with well-managed blood pressure and no history of confusion, falls, or cognitive complaints. Then she dug into the affidavit. The doctor who had submitted it had a history, 2 prior complaints to the state medical board, both related to professional ethics. One of them involved testimony in a legal proceeding that was later found to be misleading. Patricia found a precedent in Tennessee case law that allowed us to challenge the admissibility of that affidavit on procedural grounds. The evaluation had not followed, required protocols for a court-ordered cognitive assessment. It had not been court-ordered at all. It had been conducted without my knowledge or consent. She also found something else, something I hadn't known about. Renee had been sending emails to Mitchell, to the doctor, to their attorney. Patricia obtained them through the discovery process, and what they showed was a coordinated effort, timed discussions about when to file, how to present the wellness assessment, how to frame my dizzy spell from the prior spring as part of a pattern of decline. In one email, Renee wrote, "If we can get control of the property by spring, we can list it before the summer market peaks." I read that email sitting in Patricia's office on a Wednesday afternoon in February. I read it twice. Then I set it down and looked out the window at the parking lot. "Harold," Patricia said quietly. "I'm all right," I told her. I wasn't, entirely, but I would be. The hearing was set for a Thursday in March. Mitchell and Renee arrived at the courthouse with their attorney, a man named Caldwell. expensively suited, the kind of lawyer who fills a room just by standing in it. They had a paralegal carrying 2 bankers' boxes of documents. They looked prepared. They looked confident. Renee had dressed carefully, and I noticed she was wearing the pearl earrings Margaret had given her as a wedding gift. I noticed that. I will not pretend otherwise. I sat down at the respondents' table alone. Mitchell walked past me to take his seat, and he looked at me, really looked at me, the way you look at someone when you're checking whether they understand what's about to happen to them. "Dad," he said, and his voice had something in it I can only describe as gentle pity. "You really should have gotten representation. It's not too late to talk." "I have representation," I said. He looked at the empty chair beside me. He looked at the door. Then he smiled and turned to Renee and said something I couldn't hear, and she laughed, quietly but clearly enough that the court reporter glanced up. "Dad, you couldn't even afford a parking meter downtown," he said. "Who exactly is going to represent you today?" The courtroom doors opened. Patricia Odom walked in wearing a dark blue suit and carrying a single leather briefcase. She was not hurrying. She set the briefcase on the table beside me, pulled out the chair, sat down, and opened the briefcase with 2 precise clicks. Then she looked across the room at Caldwell and said, pleasantly, "Good morning." Caldwell's face did not go pale immediately. That came later. But something shifted in his expression right then. Something recalibrated because Patricia Odom was not an unknown quantity to men like him. They had crossed paths before. He knew exactly who she was and what it meant that she was sitting next to me. The judge was the Honorable Sandra Whitmore, 60 years old, 22 years on the bench. She had a reputation for patience and for not suffering nonsense in either direction. She reviewed the case file, asked a few preliminary questions, and then looked at Mitchell's attorney and said, "Mr. Caldwell, you may proceed." Caldwell's opening was strong. I will give him that. He painted the picture Patricia had warned me about: a grieving widower, isolated, showing early signs of cognitive softening, sitting on a valuable property that required maintenance and oversight he could no longer reliably provide. He cited the wellness assessment. He cited the dizzy spell. He called Mitchell a concerned son trying to protect his father from himself. Mitchell testified for nearly 40 minutes. His voice was steady, and his answers were careful. He talked about coming to visit and finding dishes in the sink. He talked about a phone call where I had forgotten we'd spoken the day before. He talked about the dizzy spell as though I had collapsed on the kitchen floor rather than sat down too quickly from pulling weeds. He was good. He had clearly practiced. Renee testified after him. She cried twice. She talked about how much she loved me, how worried they were, how hard this decision had been for their family. She was very convincing. Then, Patricia stood up. She started with the neuropsychological evaluation. She walked Judge Whitmore through every category, every score, every percentile, with the careful patience of a woman who had done this many times before. She called the Vanderbilt specialist as a witness, a small, meticulous man named Dr. Ellison, who answered every question in precise, credentialed language and concluded that I showed no indicators of cognitive impairment of any kind. Then she turned to the affidavit. She challenged it on procedural grounds. First, the evaluation had not followed the state protocols required for a court-admissible cognitive assessment. Judge Whitmore sustained the challenge. The affidavit was removed from consideration. Then Patricia asked Judge Whitmore for permission to submit Exhibits 14 through 22. Caldwell stood up. "Objection. Your Honor, we haven't had adequate time to—" "You had adequate time," Patricia said, without raising her voice. "These were produced in discovery 3 weeks ago." Judge Whitmore looked at Caldwell for a moment. Then she said, "I'll review them. Proceed." Exhibits 14 through 22 were Renee's emails. Patricia read several of them into the record. Not all of them. She didn't need to. She read the one about the spring market. She read the one where Renee had written, "The doctor says the affidavit will hold as long as no one looks too closely." She read the one from 2 years ago, shortly after Margaret's diagnosis, where Renee had written to Mitchell, "If your mother doesn't make it, we need to be ready to move fast on the property before your father has time to do anything with it." The courtroom was very quiet. I watched Judge Whitmore read. I watched her face as she moved through those emails. She was a careful woman who had seen a great deal in 22 years on the bench, and she did not show much, but her jaw tightened, and she set the last email down slowly. The way you set something down when you want your hands to be doing something other than what they might otherwise do. She looked up at Mitchell. He was looking at the table. Then she looked at me. Judge Whitmore dismissed the conservatorship petition in its entirety. She found no credible evidence of cognitive decline. She found significant procedural irregularities in the original filing. She noted, for the record, that the documentary evidence suggested the petition had been brought in bad faith for the purpose of financial gain, and she referred the matter to the State Bar for a review of the professional conduct involved in obtaining the affidavit. She also noted that the behavior documented in the emails, specifically the coordination around Margaret's illness and the intent to act before I could protect myself, may warrant further legal scrutiny, and she encouraged me to consult with Patricia about my options. Patricia was already writing something on her notepad. Mitchell looked at me once as they filed out. Just once. I don't know what he expected to see on my face. I hope it wasn't satisfaction, because that isn't what I felt. What I felt was tired, and old, and sorry. Sorry that we had arrived here. Sorry that his mother wasn't alive to see what he had become and try to reach him. Sorry that I had no idea what happened next between a father and a son who had done what he had done. Renee didn't look at me at all. There is something I need to tell you, friends. About the weeks after the hearing, I went home to the farmhouse. I made a pot of coffee. I sat in the chair by the kitchen window where I can see the oak tree in the back field, the one Margaret and I were married under 53 years ago this June, and I tried to figure out how I felt. Angry, yes. I would be dishonest if I told you the anger wasn't there. But underneath the anger was something sadder and more difficult, the awareness that my son had looked at everything I had built and everything I had loved and seen only an asset to be liquidated. That somewhere along the way, the boy who learned to ride a bicycle in my gravel driveway had become a man who could write, "If we can get control of the property by spring, we can list it before the summer market peaks." I don't know when that happened. I don't know if it was something I did or failed to do, or something that simply grew in him on its own. The way certain things grow in people regardless of what they're given. I have thought about it many nights since then, and I have not come to a satisfying answer. What I do know is what happened next. About 3 weeks after the hearing, Lily came to see me. She drove herself. She had gotten her license in January, and she pulled into the driveway in her parents' second car and walked up to the door carrying a Tupperware container of brownies she had made herself. And when I opened the door, she looked up at me and said, very seriously, "Grandpa, I'm sorry about my parents." I held the door open for her. "Come in, Lily." She sat at the kitchen table while I made her hot chocolate. She had liked it since she was small, and we talked for a long time about her grandmother, about the house, about what she had seen on her father's desk that November night and why she had called me. She told me she had been afraid of what her parents would do if they found out. She had been afraid they would take her phone or ground her or find some way to make her life difficult for a while. She had called me anyway. "Your grandmother would have done the same thing," I told her. Lily looked down at her hot chocolate. "I know," she said. "That's why I did it." Patricia had advised me about my legal options in the aftermath. There were several, and some of them were significant. I thought about it for a long time. I am not a vengeful man by nature, but I am a man who has spent his life teaching students that actions have consequences and that the integrity of our choices is the one thing no one can take from us. I made 2 decisions. The first was that I updated my will, the farmhouse, all 11 acres, the building, the contents, everything I placed in a trust. The terms of the trust specified that the property could not be sold for any reason during my lifetime, and that upon my death it would pass to Lily outright, with a smaller fund set aside for her younger brother. Mitchell and Renee were removed from the estate entirely. I had Patricia put that in language clear enough that no one could mistake it or challenge it. The second decision was that I called Mitchell. He answered on the 4th ring, which told me he had seen my name and thought about it for 3 rings before picking up. I understood that. I told him I wasn't going to pursue the additional legal remedies Patricia had outlined. I told him that wasn't a gift, it was a choice I was making for myself, because I had no interest in spending whatever time I had left in courtrooms. I told him that the house would not be available to him, now or later, and that I had arranged things accordingly. And then I told him something I had been thinking about since that March afternoon, when I sat in the kitchen listening to the oak tree move in the wind. I said, "Mitchell, I don't know what your mother and I did that made money feel more important to you than people. I've thought about it and I can't find the answer. But I want you to know, and I want you to really hear this. The saddest thing that happened in that courtroom wasn't anything that happened to me. It was what you showed me about yourself. And I hope someday you find your way back from it. Because you're my son, and I loved you before I knew who you were going to become. And I expect I'll love you after too. But I can't let that love cost me what your mother left behind. He didn't say anything for a long moment. Then he said, "Dad, take care of yourself, Mitchell," I said. And I hung up. I am writing this from the farmhouse on a Sunday morning in October. The oak tree is turning. It goes a deep amber before it drops. And there are about 3 weeks each fall when it looks like something Margaret would have stopped the car to photograph. She always did stop. Every year. 31 years of photographs of that tree. I found them on her old laptop last spring. 31 folders, one for each year, labeled with the date and sometimes a short note. The last one, from the October before she got sick, said simply, "Still the most beautiful thing I know how to see. Lily visits on Sundays when she can." She is a senior in high school now and she has plans college in the fall, something in environmental science, which doesn't surprise me at all because she has always paid close attention to the world. She sits at the kitchen table and does homework while I make breakfast. And sometimes we talk and sometimes we don't, and the house feels full in a way that it hadn't for a long while. Last Sunday she looked up from her textbook and said, "Grandpa, what was Grandma's favorite thing about this house?" I thought about it. "The mornings," I said. She liked the way the light came through the east windows when the leaves were on the tree. Lily looked at the window. The light was doing it right then, that amber-filtered morning light coming through the oak in October. "Yeah," she said, "I can see that. There are things I want to say to you. Friends, to everyone listening tonight, from wherever you are in this country, from all the places you've told me you're calling in from, Ohio and Oregon and Texas and the Carolinas and all the rest, because I know a lot of you understand what I'm talking about. I know some of you have sat in a kitchen listening to a quiet house and wondered how you arrived somewhere you never intended to go. A parent's love doesn't come with a receipt. You don't give it expecting anything specific in return. You give it because it's what you do, because that child was yours before they were anyone else's, and that doesn't change just because they disappoint you in ways you couldn't have imagined. But loving someone doesn't mean surrendering to them. It doesn't mean handing them the deed to your life because they've decided they know better. It doesn't mean accepting a version of yourself diminished, declared incompetent, set aside that isn't true. Deceit can move fast. It can look like concern. It can wear the right clothes to a courthouse and cry at the right moments and almost convince you that maybe you are what it says you are. But truth is slower and steadier, and it doesn't need to perform. It just needs to be documented and witnessed and spoken clearly in a room where someone has the authority to listen. I am 67 years old. I live alone on 11 acres outside of Clarksville, Tennessee. I make my coffee strong and I sleep on Margaret's side of the bed, and on October mornings I watch the light come through the oak tree, and I know, with the certainty of a man who is lost enough to understand what keeping something costs, that I am exactly where I belong. The farmhouse is not for sale. It never was. And before I go tonight, I want to hear from you. Where in this great country are you listening from? Drop it in the comments. I read every one.